Hi guys! Welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we continue with our discussion on the Board of Directors, and we'll be talking about removal, vacancy, and other matters. Okay, so if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? A like on this video or any of my other videos will also be very highly appreciated. Okay? Now, while as I discussed before, while directors have the power to manage and direct the affairs of the corporation, that does not mean that they have absolute power. As previously discussed, they are subject to the three duties of obedience, diligence, and loyalty. And they also enjoy their term for 1 year. And in case of non-stock of trustees in non-stock corporation, the term is 3 years. Okay, subject of course to the holdover principle, no? In which case the directors will continue to hold office until their successors have been duly elected and qualified. But what if the stockholders are not satisfied with the performance of a certain director? While stockholders cannot tell directors how they are to manage the corporation, the stockholders maintain indirect control of the corporation because they can remove and, well, of course, elect and remove directors at any time they wish. No, for elections, of course, during the proper time of election, and removal that can be anytime. Okay, and Section 27 gives us the rules on removal of directors. Now, Section 27 does not specify the cases for removal of a director or trustee. Section 27 doesn't even require that removal should be for sufficient cause or reason, no? So the directors can be removed for any cause. Just take note that in case of a minority director who is elected by virtue of cumulative voting for the representation of minority stockholders, no? He cannot be removed except for cause, no? So a director or trustee of a corporation may be removed from office by vote of the stockholders holding or representing at least 2/3 of the outstanding capital stock, or in a non-stock corporation by a vote of at least 2/3 of the members entitled to vote. Again, this is subject to the limitation that a director or trustee cannot be removed without cause if the effect of such removal is to deprive minority stockholders or members who united in cumulative voting to elect such director for the right of representation of the minority in the board. Okay, I talked about this also in the last episode. Okay, under Section 28, in case of removal of a director on the vote of stockholders or members, the vacancy created, no, because he's removed, no, the vacancy created may be filled by election at the same meeting without further notice, or at any regular or special meeting called for the purpose after giving notice, but not later than 45 days from the time that the vacancy arose. The person so elected as a replacement will be known as a replacement director, and he shall serve only the unexpired portion of the directors who removed. So if 1 day na lang natira, edi 1 day lang siya mag-serve. Okay? So he just serves the unexpired portion. Now, to actually remove the director, the law requires that such removal shall take place either at a regular or special meeting called for the purpose, and in either case after previous notice to stockholders or members of the intention to propose such removal at the meeting. A special meeting of the stockholders or members for the purpose of removing any director or trustee must be called by the secretary on the order of the president or upon written demand of the stockholders representing or holding at least a majority of the outstanding capital stock or a majority of the members entitled to vote. If there is no secretary, or the secretary, despite demand, fails or refuses to call the special meeting or to give notice thereof, then the stockholder or member of the corporation signing the demand may call for the meeting. How? by directly addressing the stockholders or members. Of course, notice of the time and place of such meeting, as well as the intention to propose such removal, must be given by publication or by written notice. So it is only the stockholders who can remove the directors. The board itself has no power to remove one of its own members as director. Why? They derive their title from the stockholders, and therefore they can be removed only by the power that appointed them. Since the law expressly confers the authority to the stockholders, then the board cannot indirectly usurp or disregard that power. Okay? The SEC, however, the Securities and Exchange Commission, the SEC can remove directors motu proprio, meaning on its own initiative, or upon verified complaint and after due notice and hearing if the person to be removed possesses disqualifications. Take note, however, that these rules on removal do not prevent a director from resigning. The director can resign at any time as long as it does not defraud or prejudice the corporation, in which case he may be held liable. Or in case a director accepts a position in which his duties as director are incompatible with the position that he accepted, then he will be deemed to have abandoned his office as director. Or when a director absents himself so much from meetings and he even announces his refusal to act as director, that is also abandonment. And these are instances when there will be a vacancy in his position as director, which we'll now talk about, okay? So in case there is a vacancy in the office of director or trustee, the rules will depend on the nature of such vacancy. If the vacancy in the office of director is due to removal, as discussed earlier, or because the 1-year term has expired, then the vacancy must be filled by the stockholders or members in a regular or special meeting. Okay? If it's due to expiration of the term, meaning the 1-year period has expired, the election must be held no later than the day of such expiration at a meeting called for that purpose. And as discussed earlier, if the vacancy is by removal, it may be in the same meeting removing the director, and such fact must be stated in the notice and agenda of the meeting. If the vacancy is caused by any cause that is not removal or expiration of term, like abandonment, or resignation, etc., then the vacancy may be filled by vote of at least a majority of the remaining directors or trustees if they still constitute a quorum. Okay, remember my discussion on quorum, because if there is no more quorum, if they cannot constitute a quorum, let's say out of 5, 3 is the quorum, but there are only 2 left. If they are not a quorum, then they cannot vote to fill the vacancy, and therefore that vacancy must be filled by the stockholders or members. But take note, there is also another qualification under the law. When the vacancy prevents the remaining directors from constituting a quorum, and an emergency action is required to prevent grave, substantial, and irreparable loss or damage to the corporation, then the vacancy may be temporarily filled from among the officers of the corporation by unanimous vote, all of them, by unanimous vote of the remaining directors or trustees. Emergency lang, Okay, the action by the designated director or trustee shall be limited to the emergency action necessary, and the term shall cease within a reasonable time from the termination of the emergency or upon election of the replacement director or trustee, whichever of the two comes first. Okay? Also, the corporation must notify the SEC within 3 days from the creation of the emergency board, stating the reasons for the creation of such emergency board. Now, any directorship or trusteeship to be filled by reason of an increase in the number of directors or trustees shall be filled only by election at a regular or at a special meeting of stockholders or members duly called for the purpose, or in the same meeting authorizing the increase of directors or trustees if so stated in the notice of meeting. Meaning that previously, let's say there were only 5 directors and then the stockholders voted to add another. Okay? That can only be done at an election at a regular or special meeting called for that purpose. Okay? As for the procedure for the election and the reportorial requirements, I've already discussed these in a previous episode, okay, on election and reporting, no? And those same rules will apply in the election of the person to fill the vacancy. Take note that any person so elected to fill the vacancy shall serve only for the unexpired term of the predecessor in office. Again, kung 1 day na nga lang natira, he serves for 1 day. Okay? But that's highly impractical. So if he has like 5 months left, just serve for 5 months. Okay? Subject, of course, to hold over in case his successor has not yet been duly elected and qualified. Okay? Finally, the last topic on the board of directors would be a discussion on the corporate officers. Okay? Section 24 says that immediately after the election of the board of directors, after the stockholders have voted for their directors, then now the directors must formally organize. Okay? They should meet and they should elect a president. That president must be a director. They must also elect a treasurer who must be a resident of the Philippines. They must elect a secretary who must not only be a resident of the Philippines but must be a Philippine citizen. And they can also elect such other officers as may be provided in the bylaws. If the corporation, take note, is vested with public interest, the board should also elect a compliance officer. That's something new, ha? The board shall also elect a compliance officer. Now, when it comes to holding positions concurrently, the same person may hold 2 or more positions concurrently, except that no one shall act as president and secretary at the same time or as president and treasurer at the same time. You cannot be both president and secretary. You cannot be both president and treasurer. But otherwise, a person may hold 2 positions at the same time. Okay? The officers now shall manage the corporation and they perform such duties as may be provided in the bylaws and or as resolved by the board of directors in a board resolution. Okay? Take note that the mandatory officers under the law are only the president, treasurer, secretary, and compliance officer in case of corporations vested with public interest. Now, the bylaws, they may provide for other officers, but the position must be expressly mentioned in the bylaws in order for that to be considered a corporate office. If the position is merely created by the board through a resolution and not through the bylaws, then that's not a corporate office. And the person so elected or appointed, as the case may be, he is not considered as a corporate officer within the meaning of Section 24. He is only a corporate employee. Again, to be a corporate officer, that position should be stated in the bylaws. Okay? So, these officers can only exercise powers that are validly delegated to them either by the revised corporation code or by the articles or the bylaws. Okay? So, if a person is a general manager, you check the bylaws. If the bylaws creates a position of general manager as a corporate officer, then he's a corporate officer. But if the person is a general manager because of a board resolution and not the bylaws, then he is merely a corporate employee. So generally, the directors or trustees are elected by the stockholders at the meeting. But the election of the administrative officers like president, treasurer, secretary, or compliance officer, or others, okay, that is entrusted to the board. Stockholders vote for directors, directors vote for officers. Okay? The board, it formulates the broad policy. I said this in the first episode of the board, no? The board formulates the broad policy of the corporation, while the actual management of the corporation and the carrying on of the details of the business operations, they are delegated to the officers. And those officers, they are responsible to the board. So an officer possesses the authority which he has by virtue of his office. That is that which is expressly conferred upon him or is incidental to perform the express authority granted to him. As to third persons dealing with the officer without notice of any restriction of authority, the officer has such power and authority as the corporation holds him out as possessing, and the corporation will be stopped to deny that. That's the doctrine of apparent authority, which says that if a corporation knowingly permits one of its officers or agents to act within a scope of apparent authority, then that corporation holds him out to the public as possessing the power to do those acts and acts incidental to that, no? Therefore, the corporation will, against anyone who has in good faith dealt with such officer or agent, the corporation will be stopped from denying the authority of such officer or agent. In other words, where a corporation allows its president to sign a contract, it clothes him with apparent authority to perform all acts which are expressly, impliedly, and inherently connected therewith. Okay? Or where a corporation had previously allowed its president to enter into contracts without a board resolution expressly authorizing him. In effect, the corporation has clothed its president with apparent authority to execute a latter contract without the board resolution, especially where that contract is later on ratified. Finally, as to compensation of the officers, it is within the power of the board to fix the salaries of the corporate officers because the power to employ carries with it the power to grant compensation. And the term of office of the corporate officers may also be fixed in the bylaws, or if it's not fixed, then they may be removed at any time by the board of directors. Okay? So that's it for our discussion on the board of directors, and that ends it for the series on the board of directors. Okay? I'll move on to corporate powers in the next episode. Okay? So I hope you may have picked up a thing or two, and I hope to see you next time, guys. Okay? See you soon. Bye.